So in this video, we'll be dealing with what is appeal and the provisions of appeal under Code of Civil Procedure. So appeal is a judicial examination that is done by the higher court of the lower court's judgment. So generally, appeal is made on the grounds of substantial question of law and not question of facts, and therefore, in that sense, the trial court's judgment will be very important. So general rule is that no new grounds and facts cannot be introduced in appeal, but there is exception for that. Exception in the sense when the circumstances is that the facts have totally changed. In such scenario, new grounds can be introduced in appeal as well. So section 96 deals with first appeal. This section states that all decree provided by court of first instance is appealable. So generally all decree are appealable. That is the general rule. But not all orders are appealable. There are only certain orders which could be appealable. That is listed under Order 43. So according to Section 96, all decree is appealable. All decree includes even ex parte decree. If a decree has been passed by the lower court via ex parte, whereas the defendant did not appear before the court, and the court has eventually passed an order. In such case, even that ex parte decree is appealable. But decree that is passed by consent of parties, if parties come to a amicable settlement and they have agreed to terms and made an agreement in by which the court gives a consent decree. So in such case, such decree that has been given uh, in with regard to that consent, that is not appealable, right? Because they have mutually in mutual understanding they have made themselves a compromise, and later they cannot appeal the same. Yeah, appeal can only be made with regard to any question of law and not question of facts. But in terms of any judgment or decree that has been passed by court of small causes, then such decree or judgment can be appealed only if it exceeds the value of the suit exceeds 10,000. Else, the decree or judgment given by small causes court cannot be appealed. And also, right to appeal is a substantive right and it is a vested right. So it is a right generally. It cannot be taken away by the courts. It can only be taken by any legislation that will be passed by the legislature. Appeal is not a different suit, it is a continuation of a suit. So we should be clear that appeal is not a different suit, it is just a continuation of the existing suit. Appeal can only be filed by the aggrieved person. So when a judgment or decree has been passed in the subordinate court, that is lower court, uh, via ex parte, that is the defendant did not appear, and in furtherance to that, the court has passed the ex parte decree, and an appeal has been made with regard to such ex parte decree by the defendant. In such case, the appellate court cannot ask the defendant why he was not present before the subordinate court. It should only decide case on merits. So, if in case of consent decree that we have dealt before, when such consent has been obtained via coercion or fraud, then in such case, on such ground, even consent decree can be appealed. We can do that by setting aside the consent decree on the grounds of coercion or fraud. It has been obtained via coercion or fraud. But there is a provision with regard to this, that is, both the parties have come to a settlement and they have made an agreement by which the defendant or any of the party is being benefited out of it, and they have enjoyed the benefit that has arisen via with regard to that agreement that they have made, relying upon which the court had given the consent decree. When the parties have enjoyed benefits out of such agreement, and then in such case appeal cannot be entertained. So this generally what I'm trying to say is, when benefit has been enjoyed by the parties, they cannot appeal, even in case of coercion or fraud. According to section 97, it talks about preliminary and final decree. So once an appeal with regard to any final decree has been made, then there is no need to appeal for preliminary decree. So there will be two decrees here: preliminary decree and final decree. When the agreed party went for an appeal with regard to that final decree, there is no need to appeal with regard to preliminary decree. Section 98 deals with the decision which will prevail. It will always be the majority's decision. The judge's majority decision will prevail. If in case it appears that there is no majority, then in such case the decree or judgment that is given by the trial court would prevail. Section 99 deals with error or irregularity. General rule is that if any error or irregularity occurs and that resulted in a decree, then the whole decree will not be uh, concluded as nullity. It will still be uh, considered as a valid decree because they are minor errors and irregularity. But there is an exception, provided that such decree that has been passed through that error or irregularity, even though there is error or irregularity, a decree has been passed, and such decree that has been passed, if it affects the merit or jurisdiction, then in such case it can be appealed, and appeal can be entertained. Question with regard to misjoinder non-joinder of effective party. So here it is just the effective party. They do not play a vital role in case in any suit, because it only leads to uh, an additional advantage to derive a decision, but they will not be a focal point. They are important, but they are not that much important. So when in such case, when such parties are subject to non-joinder or misjoinder, then on such grounds appeal cannot be made. There is exception for that, uh, even for that. If in case failure of justice take place, even in such case misjoinder or non-joinder of effective party can be appealed. That is held in the case of Kiran Singh versus Shaman Paswan. Section 99A deals with orders from section 47. So section 47 deals with certain questions that could be raised in appellate in execution court. So when a decree has been passed, when the judgment debtor is not abiding by such decree, we go for execution, right? So at that uh, situation, when the decree holder goes for execution, then before such executing court, there will be certain questions that will be raised. When any order with regard to such questions has been settled, then they are final. Upon such orders, no appeal can lie, right? But even For that, there is exception that that solution or a decision with regard to appeal, with regard to order under section 47 has been given when such decision kills the whole decree itself. In such case, appeal is allowed. So here, under section 47, there is a question that is raised in execution, and there has been a decision that has given by the executing court. So such decision is final. Okay, that should be clear. But even such decision can be appealable when it kills the degree itself. Only on such ground, such a decision can be appealed. And now we come deal with powers of appellate court. Section 107 deals with powers of the appellate court. So appellate court has power to finally determine a case, to remand back the case to the subordinate court itself. So when a case or suit is before a subordinate court and it has to decide upon a preliminary issue, like whether it is barred by res judicata or whether the court has jurisdiction to entertain uh, the sort of suit. When such case, when preliminary issues have to be settled by a higher court, the subordinate court gives the matter to the higher court. So in such case, as soon as the higher court decides upon such preliminary matter, it can again return back the suit to the lower court, and that is one of the power that is available to the appellate court. And the appellate court can frame issues here. It can refer to retrial. It can ask the subordinate court that just conduct retrial, just start everything from the beginning. It can make such directions, and even in case any additional evidence have to be taken, the higher court can make such directions to the lower court, directing the lower court to take more evidences with regard to a particular suit. Also, the appellate court have same power as the court of original jurisdiction. So these are the powers of appellate court. Order 41 deals with rules with regard to appeal from original decree. So Order 41 deals with the first appeal rules. First appeal can be filed with a memo of appeal in an appeal form, and such memo should be signed by either by parties or their pleaders, with a copy of judgment and the grounds of the objections must be stated in such memo. So this is the procedure. So if any appeal that is made against this money suit decree, the lower court has passed a decree with regard to money suit that the judgment debtor has to pay so and so amount. In such case, the judgment debtor can appeal to the higher court, but on a condition that he should deposit the decreed amount first, and only then his appeal can be entertained. So this condition applies only in case of money suit. So objective of this particular provision is to prevent the delay on part of judgment debtor. It is not mandatory uh, to the appellate court that it should restrict itself with the grounds of objections that has been stated by the parties. It can go beyond the grounds that is stated by the parties. It can frame additional grounds as well, the appeal. And such grounds of objections that has been stated by the appellant, such grounds of objections can also be amended within a reasonable period of time. When grounds are not properly drawn, like when the appellant files an appeal with erroneous ground without any proper justification, in such case, it can lead to rejection of the appeal, or in certain cases, the objections would have been justified, or it would be reasonable. The objections would be reasonable, but it has not been filed in the court of proper jurisdiction. It would have been filed, the appeal would have been filed the court of incompetent jurisdiction, and therefore the court directs the appellant to go and file a suit in a competent court of competent jurisdiction. In such case, it will be returned. Time limit to appeal. So in each stage, like first appeal, second appeal, and Supreme Court cases, there are certain time limit that has been provided, and it has to be abided. If in case the limitation of time, the limitation period has exceeded, and after that the appellant comes and files a appeal suit, then an application for condoning the delay must be filed. And now uh, we're talking about the stay by appellate court. So when a decree has been passed by the lower court and an appeal has been entertained by the higher court, or an appeal has generally been made to the higher court, in such case, so mere appeal is not equal to automatic stay of execution. You have to file another petition before the appellate court or the court that has passed the judgment to stay the execution. So if you don't apply for execution, the stay of execution, in such case the execution continues, right? So it is a general rule that mere appeal is not equal to automatic stay on execution. So on such application for stay of execution, these grounds have to be stated. Only when these grounds are satisfied and the court finds it to be genuine, that substantial loss will take place, or application of stay has been filed without any delay, and security for performance is submitted, then court, after considering all these factors, can entertain application for execution stay of execution. Procedure on admission of appeal. So as soon as the appeal has been entertained by the appellate court, then such appeal will be entered in the appeal register, and the court will fix a date for hearing if the defendant does not appear before the court in that appellate court. In such case, it may pass in ex parte, but even this ex parte order can be set aside and rehearing can be allowed. So when the appeal has been admitted, as I said before, the court will fix a particular date for the first hearing. And here the appellant must prove that appeal is worthy, and it is not worthy. Uh, the appellant must prove that it is worthy, and if it is not been proved that the appeal is worthy, then in such case the court will dismiss the appeal. If There are two circumstances here that when defendant does not appear. In such case, the court will pass orders uh, ex parte. When appellant itself, so appellant is the person who files an appeal. When he himself does not appear before the appellate court, then in such case, the court may note grounds for dismissal and thereby it may dismiss the appeal. So appeals, these are general provisions. Appeals can be summarily dismissed. That is one thing, and if not, the appeals can be disposed within 60 days. If summarily dismissed, then the appellate court should send notice to both the defendants as well as the lower court that has passed the original decree or judgment. Readmission of appeal can be allowed only if it is a suit that has been dismissed for default, that is, uh, due to some errors, the suit has been dismissed. Only in such case readmission can be allowed. But the person who is asking for readmission should show a sufficient cause as to why the court should entertain the readmission. There may be situation where a decree could partly favor the defendant and partly favor the plaintiff. It can go the other way around as well. That is, it may partly be a disadvantage to a defendant and it may partly be a disadvantage to the plaintiff. So in such case, there is a probability of both the parties filing an appeal. In such case, when two appeals come together, that is called as cross appeal. So in such case, the court will club both the appeals together and it will be heard. So it is a situation of cross appeal, but one of the party will be will not be filing an appeal, even though it has partly disadvantaged him or it has benefited him. The decree has benefited him partly. He will not go for appeal. He had failed, and the limitation period got over. Then, in such case, he can file cross objection, right? But such cross examination must be filed within 1 month since the memo of appeal has been submitted by the appellate. Remand of case by appellate court. That is, as I said before, it is dealt under Rule 23. So, a lower court has decided a preliminary issue and made appeal to the higher court. And when the higher court decides such preliminary issue, so here the lower court has to decide a preliminary issue and therefore it cannot decide, and it makes a reference to the higher court. Reference the term in general sense. It uh, sends the suit to the higher court, and higher court, once it has decided upon such preliminary issues, it will send back the suit to the lower court. So that is called as remand. So the higher court, the appellate court, will make remand with following directions, that you, the lower court, should abide by these directions that is given by me with regard to any particular remand of a suit. That is, the appellate court can direct the subordinate court to fix issue in a certain way. It may direct you have to fix this issue in a certain way, and whether such subordinate court can entertain any further evidence additional to the evidence that has been already entertained. The appellate court can make such directions that you, subordinate court, should entertain more evidences. The appellate court can also give directions as to you have to give other degree, you can give any other degree. Such directions can be issued by the higher court. while making remands. And the appellate court can also give directions as to how to proceed further with the case. And the appellate court may also ask the lower court, the subordinate court, to make findings on only certain issues and ignore other certain issues and pass the order. It may also direct as such. So all these are directed by the appellate court to the subordinate court with regard to remand. So there is also a concept called retrial, and retrial in the sense while remanding, the appellate court can also ask for retrial. You have to conduct trial all over again from the beginning. So such retrial can only be directed only on the grounds of when trial is defective. So the subordinate court has conducted a defective trial and there has been a change of circumstances. It is not like as before. There has been new circumstances that has arose in the case and therefore it needs a retrial. In such case, the appellate court may make such directions. Rule 24 deals with when appellate court can deal with matters in any other grounds apart from those derived from the original decree. As I said before, the appellate court will not be restricted itself to the grounds that is mentioned or stated by the uh, either appellant or the court that has passed the original decree. It may go beyond that. It is not restricted to the grounds that has been passed, grounds on which upon which the decree has been passed by the lower court. It may go beyond that. And Rule 27 deals with appellate court can examine evidence entertained in the lower court and may entertain additional evidences as well. So generally in appellate court, new evidences are not entertained. That is general rule. But in certain circumstances, the appellate court may also entertain new additional evidences on only in these grounds. That is, the the subordinate court has refused to admit any particular evidences that ought to have been admitted, and despite due diligence, there is no knowledge about such evidence. Right? In such case, the appellate court can entertain additional evidences. And there is also a situation where the appellate court cannot pass or give judgment without entertaining new evidences. So there is generally a lack of evidence there in the suit, and therefore, for the proper disposal of the case, the appellate court has to is ought to get some evidences. In such case, even the appellate court can entertain new evidences, that is additional evidence. Judgment in appeal. So this is the judgment that is with regard to the first appeal. It shall be pronounced in the open court, that too in writing, with points of determination, and it may state the reasons as to why the first appellate court had concluded with such with regard to that decision, how it attained or made such conclusions. It may state the reasons. So the relief, the first appellate court may either reverse the findings of the subordinate court. It may vary, it can make certain variations and pass order, and it may conform the order or decree, that is the judgment that is given by the subordinate court. It can do all these three things, the first appellate court. That is provided under Rule 32. This is okay, but when it comes to variation of the judgment that is given by the original original decree court. When the appellate court passes a judgment with slight variations, then the appellate court must specify and state the relief, because it is only varying. It is not either it is not refusing the whole judgment or reversing the whole judgment that is pronounced by the original decreed court, or neither it is confirming nor it is reversing. It is just making some variations with regard to the decree that is passed by the lower court. So in such chaotic situation, the appellate court must specifically state the relief that is to be granted. Decree in appeal. So the appellate court, if in case it reverses or if it gives it passes any decree with some variations, in such case the dissenting opinion judges, that is there will be certain judges that would who may not agree with the majority judges, right? So they are not necessary to sign the decree. Only the majority number of judges who is willing to make a particular judgment may sign it, and the dissenting judges need not sign the decree. And the certificate copy can be obtained by the parties. And now we come to the second appeal. Second appeal is dealt under section 102 103, and the relevant order is 42. Second appeal is generally filed in High Court, and strictly speaking, it should be only based on substantial question of law when it comes to second appeal. And there is no second appeal with regard to any orders. So it is not a decree, it is order. And while filing the second appeal before the High Court, similar to the procedure that is followed in the first appeal court, we have to file a memo of second appeal with we will not here mention or state the objections. We will just state the substantial question of law, because that is what required in the second appeal. The grounds for objection is not necessary, but the substantial question of law must be stated in the memo. So High Court, by relying upon and analyzing all the substantial question that is raised with regard to any law, it may frame issues with regard to such substantial question of law. And under section 100A deals with when second appeal cannot be entertained. That is, after first appeal, no further appeal is entertained. So when a decree that has been passed by a single judge of a high court, that could be appellate decree, that is first appeal, or the original suit itself has been passed by the single judge of high court, then in such case second appeal is not entertained. Section 101 deals with when second appeal cannot be entertained, except section 100, that is second appeal cannot be entertained from orders. That is, when an order decree is appealable, but orders are not generally appealable, and therefore they are not eligible for second appeal. And the money suit that is valued less than 25,000, then in such case no second appeal shall lie. And there will be certain suits that will be expressly barred by the code itself, then in such case second appeal will not be entertained. And but there will be certain suits and cases where there will be both question of law, that is substantial question of law, as well as facts. It will be mixed. It cannot be dealt with isolation. It will be mixed, both question of law as well as facts. In such case second appeal can be entertained, because here such question of law will be totally relied upon such facts, and when such facts itself is not proper, then of course it is a mixed problem, and therefore in such case the second appeal can be entertained. And new point of law has arisen, like there has been drastic changes with regard to laws that are involved in a particular suit. In such case second appeal can be entertained. And second appeal court is not bound by the lower court's findings, like there has been two decree or judgments or decisions that has been made before the second appeal. One is by the original court of original jurisdiction, and the first appeal court, and the second appeal court is not bound by any of their findings. And what is substantive question of law? We're often coming across this particular term, that is substantive question of law. So what is given under order 42? So under order 42, it is substantial question of law with regard to the parties. Between the parties, if there is any substantial question of law, it refers to that. That is only restricted between the parties. But in case of substantial question of law, that is, we are talking about the Supreme Court now. In such case, it is a general question of law, and there has been no precedence that has been uh, set by the Supreme Court in any of its previous cases, and there is no such precedence. And in such case, the Supreme Court has to provide a decision and set a precedent. In such case, it deals with general question of law in the sense of order 45. For example, uh, substantive question of law, I've given three examples here. That is the court of original jurisdiction and first appellate court had find as made a finding without entertaining a proper evidence, and it has disregarded relevant and admissible evidence which should have been taken, which should have been admitted by the lower courts. In such case, that is a substantial question of law, and irrelevant evidences has been considered by the lower courts. That will also be construed as a substantive question of law. And under section 103, it deals with the power of the High Court, that is with regard to second appeal. So High Court can take additional evidence, that is in second appeal, we rarely witness that any court is taking new evidences in the second appeal. So it generally doesn't happen, but in certain cases there are exceptions for everything. So High Court may take evidences in second appeal if it is necessary for the disposal. In such case, the High Court can take evidences, that is in the sense when such evidence has not been taken in the original decree court, when the court of original jurisdiction has passed a particular judgment or order without even considering an evidence that is really important, the case, and it has not been taken even by the first appellate court. In such case, when it seems that the High Court is satisfied that no sufficient evidence has been taken in the trial courts, that is both the subordinate courts, in such case, only for the reason that it is necessary for disposal of such suit in second appeal, in such case even the High Court can take additional evidences to determine a particular issue of facts. And section 103 generally uh, deals or says that all rules in order 41 applies to order 42 as well, that is second appeal. So what are the rules that is applicable to first appeal applies for second appeal as well. So in this lecture, in this video we have just we have just dealt with the first appeal and second appeal. Yeah, that is about this video. Thank you.